Thank you so much, sir, for giving your time today.
My pleasure.
And we have been here from past few days. How was your experience with this third annual ILA conference at the Jara Fort in Rajasthan?
You see, as you have yourself mentioned, it was fascinating experience from so many angles. Number one, Tijara Fort, such a wonderful place, and the way it is created now, it's like paradise. So coming here itself was a pleasure. Then coming to ILA and its third edition, I feel that it's always, the improvement over the previous one. Of course, all three editions have been very, very successful, but this one was the best by far. And if I may say only in one word, I have attended so many insolvency conferences, have been attending for last 25, 30 years now, and many international conferences on insolvency. I think it has even beaten international standards, if I may say so in one line.
Absolutely, absolutely. So many insolvency professionals at one place sharing all the insights.
Correct.
So, can you please tell me the reasons why mediation should be preferred apart from the timelines?
Yeah, okay. As I said there also, you see, insofar as insolvency is concerned, this is one kind of litigation or dispute which needs to be resolved as quickly as possible.
Right.
And that is why even our IBC, Insolvency and Bankruptcy Code itself, sets those timelines within which the courts have to resolve. So time is a very, very important factor. At the same time, because of less infrastructure, less number of judges, so many cases before the courts on NCLT, etc., they are not able to decide it within the timeline specified therein. So therefore, in such a ecosystem, mediation comes very handy, as it is, the dispute can be resolved within days. Sometime in one day, in one sitting, and there's no timelines as such, in the sense that you have to sit from 10 to 4 during court hours. I've seen mediation starting at 10 o'clock, 11 o'clock and going up to midnight, and the dispute decided. So therefore, time, which is very important factor in insolvency, their mediation becomes a very, very significant tool for resolving those disputes. That is one. Apart from that, as you said, that apart from time, what are the other factors? I have been advocating it, and this is my hypothesis, and I have written also a lot on that, is that look, mediation is in a way, in many situations, I won't say universally correct, but in many, many situations, most of the situations, mediation is the best form of access to justice. The resolution which is arrived at, and it is by way of settlement, which is to the satisfaction of both the parties, and that is why in mediation we call it a win-win situation. So therefore, a win-win situation vis-a-vis adversarial system, as you rightly mentioned, which is in our this judicial process, whether it is insolvency or any other kind of cases. So in adversarial system, the two parties are taking their positions, and the court is deciding who is right, who is wrong, and is deciding. And likewise, which the court would be deciding whether the parties have been able to this RP, who is appointed resolution professional, is able to come before the court with a resolution process or not. And if it is not successful, the company may go into liquidation, etc. But then, the nature of the dispute, the courts or the tribunals do not have third alternative, which I call a third alternative, and this is the third alternative which is available in mediation, where and when we talk of third alternative, it is not only one third possibility, endless possibilities, because disputes, depending upon the situation, depending upon the what are the interests of the parties, because in mediation we go from positions to the interest. We look what is in the interest of the parties and what can be, and these disputes are many times resolved keeping in view those interests of the parties. And therefore, the vis-a-vis adversarial here, there may be 5, 7, 10, 15 possibilities, and the parties may choose which suit them the best. And therefore, that is why we call it a win-win situation, and that is why I treat this as the most important facet or aspect of mediation, which is there in no other dispute resolution mechanism, whether it is arbitration, whether it is court litigation, etc. So this I would call, and that is why I say that it is the best form in many situations, best form of access to justice. Not it is timely, or not only timely, it is least expensive and non-adversarial, where the parties go into what is best for them, they choose, the mediator facilitates that. And in insolvency, this becomes all the more important because in insolvency there are, and when the resolution process, the company is at the verge of bankruptcy, and we want to salvage that company, because that is the first approach under the IBC, that if the company can be saved and resolution process can be worked, even if it goes from the hand of the present shareholders or the promoters to third party which can buy that company, but it is in the interest of the economy of the nation also that the companies are saved, unless there is no option but to liquidate that company. So therefore, in this scenario, the interest of the stakeholders, whether these are promoters, even if they have to go out, they will like to get, because they had invested, they had started this company, whatever they can salvage for themselves. Then the creditors, that creditors' interests are there, who had put in money into that particular industry or that business, and they would also like to get as much as possible if they can get. And the creditors are of various kinds. There may be secured creditors who have, like banks, etc., who have given loan. There may be, we call it corporate creditors, that who had supplied the goods, etc., and for that they have to take money. But then they have different kind of interest, and under the Act there are different priorities given. There may be creditors in the form of even the government. Government has to take its taxes, its own statutory dues. Suppose some excise duty is to be paid, and say custom duty is to be paid, or GST is to be paid, or other income tax, etc. So they also may have their statutory dues of not statutory now. It's not there. It's not statutory, but like electricity bills and other which may have to. So all these kinds of creditors want their share. And in mediation, it is possible to take interest of all. In adversarial system, as I say, under the Act, we have the priority. Okay, the secured creditor will get first. If that is not, there is no such thing, then second creditors may not. Waterfall mechanism comes from one to second to third category. But then in mediation, there is a possibility, and there are disputes then, whether one belongs to this category or doesn't want to. Everybody wants to be treated as secured creditors, so that that secured creditor is able to get, and those disputes land up whether he is a secured creditor or not. Those issues are adversarially decided, and then they lands up to the Supreme Court. All these are saved in mediation, where the mediator can see that, look, what are the interests of different parties and how they can be balanced and they can be resolved, and the parties may agree to that.
Thank you so much, sir, for elaborating this. Right now we are seeing USA who has adopted mediation from past 30 years, and they are relying on standing orders and their local laws. But do you think India is going to accept mediation as a viable option for dispute resolution in insolvency?
You see, one thing is there now, unlike US, in India we have enacted Mediation Act. I feel pride in this thing that just before my retirement, 2 or 3 days before my retirement as Supreme Court judge, I had given a judgment. And in that judgment, I had said that time has come, because there were some elements of mediation involved in that. So I had said that time has come that we should pass now Mediation Act. And so I urged the Parliament to take steps in that. So I feel happy that it has happened. Another important thing is the Singapore Convention on Mediation, which took place, and it's almost now 6 years, I think. And this was for the reason when the arbitration became successful, and particularly international arbitration, what was the main reason? The arbitration awards which are given, they have to be recognized also. And we have our Indian Arbitration Act, it was there 1940 Act. So under that it only applied to domestic arbitrations. So then if there is a international arbitration, suppose dispute between Indian party and say German party, but it is decided by Singapore International Arbitration Center. So now that award is to be implemented in India. So there has to be some mechanism, some statutory mechanism to enforce that award. So for that, this New York Convention, which was enacted at that time, and based on that, many countries passed their legislations for acknowledging the award passed even in other countries and for enforcement of the awards. Same thing has happened with mediation now. Now in mediation, just to, because mediation, cross-border disputes also are there, and in insolvency, there are cross-border insolvencies are there. So therefore, if something is settled in mediation, say in America or in Germany, where and in that mediation there is an Indian party which has to pay something under that mediation, which settlement has also taken place, means Indian parties has also agreed to that. But then if Indian party is not now paying, and that mediation comes to that particular mediation settlement is to be enforced, how it should be enforced? For that, UNCITRAL, like it came with New York Convention, they came with that is what I am saying, Singapore Convention. So therefore, for that purpose also act is needed. In India, good thing is India became signatory to that on the very first day when the Singapore Convention was signed. But under our constitution, even if there is an international convention on which India is a signatory or any covenant, that does not become a law automatically enforceable in India, which is a position in United States. Here it becomes enforceable if domestic law is passed on that basis, acknowledging that convention, and which has not happened so far. But that was one of the reasons that Mediation Act was required. Of course, Mediation Act has come where the Singapore Convention is still not there, but there are some other reasons for that, some valid reasons also, as if the government is taking step back and has not done, but that may also happen tomorrow. So for this purpose also, I would say Mediation Act is necessary statutory law. In America, if America has become signatory, as I said, it automatically they don't need law. But then in order to boost mediation, Mediation Act was required, that so that it becomes a sort of systematic process. Not only the process, etc., it is also administered in a systematic and with a statutory backing, and for that purpose Mediation Act has come. So this is a welcome step, and in view of that, now question is, when this act was passed, there are various, of course there may be general disputes which can be settled through mediation, but then there are some disputes of specific domains, specific sectors. Like there may be electricity disputes, there may be say telecom disputes, there may be consumer disputes, there may be disputes among the shareholders of a company, there may be insolvency disputes. Now the question is whether, one of the issue which was discussed was whether for insolvency the provision should be made under the IBC itself, Indian bankruptcy code, insolvency and bankruptcy code, or it should be in the mediation. So this still remains, to cut it short, I mean, and not elaborating at this stage, but this remains still one thing which we have to, I mean, the Mediation Act is silent about that. It may be, as I said in my address in the previous session also, it may be good, it may be bad, there are both aspects of it. Bad in the sense that there is no clarity today, whether because under the Mediation Act, it is the Mediation Council of India which has been formed, and it is Mediation Council of India which will be now regulating. It's in a way regulator which will be regulating the mediation process, which may come out with the rules, etc. But under the Insolvency Act, we have another regulator, IBBI. So it is ultimately, so which when it comes to mediation, IBBI may not have role, it is this Mediation Council which may have a role. So to some extent there may be overlapping, or whether IBBI should take control or this MCI should take control, etc. But anyway, those disputes will be resolved in the beginning. So therefore that is one aspect. But the good thing is that it gives us room to play around, and we can, in the absence of such statutory provision, we can imbibe and we can take the practices which are followed, as you mentioned about US practices also, which are good practices about the two parties and multi-party mediations in insolvency. Multi-party mediation is very, very important facet because many parties are involved. So it will be easy to take those particularly in a common law countries. I mean, if the mediator adopts such practices, the courts are going to approve that if it is in the larger interest of the parties.
So there were two suggestions which were given during the panel discussion. One was of centers, IBC centers, which are not there. And the second one was of digitization, where we are talking about and how we are going to have the multi-party in that, because that is going to be difficult to manage. So what do you have to say on these suggestions?
You see, as far as IBC is concerned, the centers are concerned, let me tell you one thing. This is under the Mediation Act, there is a provision, so centers will have to be created. But having said that, there is one important development which has already taken place, which is this, that we had, when this mediation movement started after Section 89 was added, and in order to ensure that mediation is successful in this country, the Supreme Court had formed a committee called MCPC, Mediation and Conciliation Project Committee. And it is under that committee, and the mandate of that committee, it is headed by senior most judge of the Supreme Court. I was also a chairperson of that MCPC for some time. And under the mandate of that, and the government also supported, because today's government is supporting mediation in to large extent. Then we have that what we call NALSA, National Legal Services Authority. So National Legal Services Authority at the top under the Legal Services Authority Act. Then we have state legal services authorities when we have district legal services authorities. So therefore there is legal service authority in every court. And it was also at that time, about 5-6 years ago, or even little more than that, the Supreme Court along with the government provided the funds to NALSA, and Supreme Court ensured that these mediation centers are set up in all the districts. So therefore, and it is particularly because of Section 89, the court annexed mediation, where the court sends the case already pending in the court, and court sends it for mediation. So those mediation centers are there. Of course, when we talk of IBCs, these are different centers, because it is not necessary that it has to be only court annexed. It may be pre-litigation mediation also, which we want to encourage, that not only when the parties have gone to the court already, then we go for mediation. Why not go for mediation even before going to the court? For that, these centers are necessary. But for time being, my take is that those with the, in association with or in collaboration with those centers which are already there, that they can also cater for this kind of work as well.
Right, right. Thank you so much, sir, for giving your time. It was a wonderful discussion, and I hope we are going to have a fabulous 2026 ILA conference.
Thank you very much, and thanks for your good wishes.
Thank you.